All right, everyone, we'll get started. All right, ASG's there.
Yeah, they on here.
All right, ladies and gentlemen, good afternoon. My name is Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. What is our SAP reset date? I see it in the chat. 10/3.
Yes, ma'am.
Okay. SAP reset date is October the 3rd. I want to begin by reminding everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to remind the defendants that you have certain constitutional rights. The first being that you have a right to representation. You should know who your attorneys are by now. The second right that you have is the right to remain silent. Anything that you state about the facts, the circumstances, or the occurrences of this case can and will be held against you. Listen to your attorneys and follow their lead. First case.
Good afternoon, Judge Mincy. This is going to be position number 12, Mr. Yusef McLean.
All right, thank you. No add-ons, right?
We have one add-on.
Oh, no. Who did that? Okay, I hadn't seen it yet.
Okay.
It was on the pull sheet though, so it's nobody new.
Oh, but there is or isn't an add-on calendar?
It's one person, Boozer.
Oh, okay. All right.
If you not receive it, I'll send it to your personal email.
Thank you. 24 CR 006588E, Yusef McLean, charged with 1 count of criminal trespass.
Yeah, he got 40.
40.
2020. Yes, 2024 shoplifting.
Oh, question, please. Did go ahead and interview him since I did not?
Yeah.
Good. Okay. Thank you. Thank you.
Got an open case out of Alabama. Forged instrument, first degree. 2022 shoplifting conviction. 2022 FTA probation. 2021 trespass conviction. 2021 FTA. 2021 shoplifting conviction. 2020 entering auto obstruction conviction. 2018 FTA and probation.
All right. State.
Good afternoon, Judge Heather
Good
Tucker. I'll
afternoon.
be handling the second half of the calendar.
Okay.
We're asking for a $500 surety bond in this case with the stay away from the Kroger located at 590 Cascade Avenue. This defendant has previously been advised to leave this location multiple times. He was also advised to leave earlier in this day before he was even arrested on this count. He was previously trespassed for shoplifting, and you heard he has multiple cycles, many cycles, 40 cycles, and most of them are theft by shoplifting. So for those reasons, we'd be asking for that $500 surety bond with the stay away from Kroger.
All right. PD Cook.
Yes, Your Honor. We have no objection to any of the conditions regarding stay away or no further contact. My client is 39 years old and he's lived in the area his entire life. At this point, he's not employed. He has no income. So we would be seeking a signature bond at whatever level the court deems appropriate.
All right, I'm going to order the $500 surety bond. and a stay away from the Kroger on Cascade Avenue. Gotta stay away, Mr. McLean. No drugs, alcohol, weapons, or guns while on bond. That's it.
All right, here we go. Come on, McLean. Ron, you give me 30 seconds.
Okay.
All right, next we're gonna go to position number 11, Mr. Massey. He has private counsel.
Okay.
Good afternoon, Your Honor. Manel Crusoe on behalf of Mr. Masney.
Hi, good afternoon. This is 24 CR 006587J, Christopher Mastany, charged with one count of criminal trespass and damage to property. Pretrial.
First.
Great. State.
I'm sorry. I'm sorry. I heard position 11 and I didn't think it was me, but this is Mr. Mastny.
Yes,
Yeah.
Christopher Masney.
Okay, my apologies. So it's my understanding that the bond is currently set at a $600 surety. We would consent to reducing it to $1,000 surety signature bond through the jail with a stay away from 252 Skyland Drive in Roswell. In this case, the defendant damaged a bedroom door, used a piece of the door to make a hole in the hallway wall, and then broke a window in the home of the victim, Jeffrey Masney. We did speak with this victim. It is the father of the defendant. He stated that there are some MH issues, and so they're trying to deal with that. He did let us know he would be on the Zoom today, so if we could sound for Jeffrey Masney.
He's on.
All right. Where is he, Mr. Mastany? Was it Jeff?
Yes, ma'am, I'm here.
Okay. I don't know that I need to hear from you, unless there's just something earth shattering. Of course, we don't talk about MH issues in open court. We would go into a breakout, but I don't know that it's going to, affect my decision, so much as because it's his first anyway. So if you're okay with not addressing the court, unless it's just something that you have to tell me, as long as it doesn't deal with the MH, then I will allow you to speak.
Judge, if I may, if that's okay, just on behalf of the family,
Mhm.
the MH is correct. The stay away would be of a concern given that that is his primary residence. He just turned 19 years old and he resides at that home. He has no other place to go. If the court wants to go into a breakout room, I'm happy to address plans that we have in place with Mr. Masney's father, with Jeff Masney. But
All right.
at the
And
court's
State, yeah. State, do you think you need to, or I will go ahead and do the no further violent contact, let him return to the home. I didn't realize he was only 19.
Yes, Judge.
Right. As long as there's that no further violent contact, I believe returning will be fine.
Okay. And it sounds like Dad has a plan in place, and as long as that's there, that may also obviously help. I do usually ask the victims, if they're in fear or afraid, because we want to make sure they're going to be safe. And so counsel is
Your
father-
Honor, would there be a condition of a bond based on what you're saying for some kind of MH eval or something?
Generally, I tell them to go with what they've been ordered to do and to stay on medication. I do say that. And if you need anything stronger than that, then we can go and break out to discuss.
Yeah, at the court's discretion, but that was something that I was wondering with regards to the no violent contact, if some kind of order.
Okay, I will do that. Let's go with the $1,000 signature bond through the jail. Since he's 19, he doesn't need a cosigner. And Sometimes I say that they will be released to the custody and care of their parent because they are possibly, I mean, he's just 19. And I don't know if that needs to be said or not. Otherwise, he could get out and just be kind of free and willing. So I don't know. Is dad picking him up?
Yes, I believe so. Is that correct, Mr. Massey?
That's correct.
Okay.
Either dad or mom.
Yeah, dad or mom, correct.
Well, let's put on there, Miss Champion, that the defendant is to be released to the custody and care of his parents. And that there's no further violent contact with the victim or his parents, and that he will comply with all treatment recommendations for treatment and take his medication. And no unprescribed medication, drugs, alcohol, weapons, or guns while on bond. And I think that should do it.
Okay.
All
Yes.
right. Thank you all.
Thank you, Judge. And may I just request a copy of the order once it's filed, please? My entry was e-filed, but if I may get a
Then will
copy.
she automatically get one when it's e-filed, you all? Or does she have to?
The order will be scanned onto the case once it's filed in.
Uh-huh. So she just goes back on there and she can print one out.
Yes, ma'am.
I would joke with you a little bit. Postage is very high these days, but but you can get it off the e-file system.
Yes, Your Honor, no problem.
Okay.
Wonderful.
All
Thank
right.
you.
Thank you.
That concludes my business. May we be excused, and can Mr. Massey be excused as well?
Yes, you all may be excused. Thank you.
Thank
Good
you.
luck to you, Mr. Mastney.
Thank you.
Thank you, ma'am.
All right.
Next, Your Honor, is going to be position number 18, Ms. Tamay Williams.
18. This is 24 CR 0065993F. Tamay Williams, charged with 2 counts of simple battery family violence. Pre-trial.
12, 2024 shoplifting, 2016 probation, 2013 and 14 FTA.
Okay.
That's it.
State.
Yes, Judge, we would be asking for a $3,000 surety bond. That's $1,500 on each count. A stay away from 3038 Washington Road in East Point, and have no further contact with the victim, Timothy Kelly. This incident arose from when Mr. Kelly was returning home from his daughter's funeral. He said they got into an argument and the defendant grabbed his shirt. The victim grabbed his phone to try to record him, and the defendant then approached him and punched him in the stomach. We have had contact with the victim, and he let us know he will be on the Zoom. They used to be in a relationship, but are now just roommates. They do both live at the incident location, but share no children. Additionally, the victim says that this defendant has an anger problem and a drug problem, that he intends to take her to a drug rehab facility once she's released. He's not in fear of her. He does want her to come home. He thinks the drugs are the main issue. If he is on Zoom, if you would like to add anything, Mr. Timothy Kelly.
Right. Mr. Kelly, do you wish to address the court today? Yes or no? I don't know if I see him, Mr. Kelly.
There's not a Kelly on the line, Judge.
Okay, it's not on. Okay. All right, go ahead, PD McLean.
Yes, Your Honor, my client's 38. She has a 4-year-old child. Despite having some past arrests, we would ask for
Your connection's terrible. Can't hear
be
you.
the lowest type. The lowest type of surety bond the bonding companies want to touch and make a profit would be about 1,000. So we would ask the court to consider one of those two options because she's got the 4-year-old and some of her arrests were somewhat in the past. Got a little age on them.
Okay, I'm going to,
And Judge, I apologize. I wrote out my recs before I got my victim notes. So because he does want her to come home, we would only be asking for no further violent contact.
all right, I'm not inclined to do a signature bond, but certainly, a surety bond. And I will, order $3,000 surety bond, 1,500 on each. I will order no further violent contact with Timothy Kelly and no unprescribed medication, drugs, alcohol, weapons, or guns, while on bond. And that should do it.
Next, Your Honor, we're gonna go to position number 9, Miss Alexis Harlow.
All right, 24 CR 006602C, Alexis Harlow, charged with 1 count of theft by receiving stolen property. Pretrial.
17, homeless out of Indiana. 2023 was the last possession of marijuana. It says visiting a common nuisance. 2022 domestic battery, 2019 probation, 2019 possession of a controlled substance conviction, 2018 probation, 2017 possession of a controlled substance conviction, 2016 contempt of court, and 2015 FTA drug paraphernalia conviction.
Huh? All
Yes,
right, Attorney McLeod. Oh, I'm sorry. Go ahead, state first.
Thank you, Your Honor. This is a dual arrest. The other defendant is the person that's on the add-on, Aquavius Boozer. This incident occurred September 19th, 2024. The incident location is 185 Mitchell Street Southwest. Officers responded to a call regarding a theft at the incident location. They observed surveillance footage that showed defendant Boozer and defendant Harlow and another man sitting in a parking lot near the incident location. The unknown male walks up with a bucket of tools, then proceeds to put the tools down, and then the defendants both walk up to the bucket, pick it up, and then walk away together with the bucket. The building engineer told officers that the tools taken cost about $100. The defendant currently has a $1,500 surety bond. We would ask that that surety bond be kept in place based on her criminal history and the fact that she's not a resident of Georgia, so she does pose a flight risk. Stay away from the incident location, no further contact with her co-defendant, Aquavius Boozer, no drugs, weapons, or alcohol while out on bond.
Okay. Attorney McLeod.
Yes, Your Honor. As Petrel has stated, my client is currently homeless. So she's not in a position to pay for bond. She tells me that she doesn't know what happened. She was actually just talking to the cross defendant, just in a conversation with them. And shortly thereafter, they were arrested. She didn't steal anything. She doesn't know anything about any stolen items. Of course, I've not seen this alleged video, but it seems to me, based on what she told me, that she was just talking to someone, and maybe the two gentlemen may have been involved in stealing something or in picking up something that did not belong to them. But my client doesn't know anything about it, Your Honor, and certainly had no intention to steal anything. I do not believe I heard anything theft related on her record. So I would ask the court to consider giving her a signature bond, even though she does not have a residence here in Atlanta. I just think given the nature of the charge and the fact that she asserts that she didn't know what was happening, that a signature bond would be appropriate. Nothing further, Your Honor.
And we would be opposed to a signature bond, but Your Honor, if you do want to lower her surety, the state would be okay with that.
All right. I'm going to order $1,000 surety bond. And I'm going to order stay away from 185 Mitchell Street Southwest. No further contact with the co-defendant and Tavius Boozer. And no drugs, unprescribed medication, alcohol, weapons, or guns while on bond.
Thank you, Your Honor.
Thank you.
Okay.
We're doing a companion case.
We are. Your Honor, we're gonna go to Mr. Boozer, and he's actually add-on 1.
Okay. All right, this is 24 CR 006604B. And that's Aquavius Boozer, charge of 1 count of theft by receiving stolen property. True trial.
42, 2024 FTA. Got to open shoplifting in state court and obstruction. Got to open felony shoplifting in superior court. 2022 possession of drug-related objects conviction. 2016 probation. 2015 FTA. 2014 possession of cocaine tampering conviction. 2012 probation simple battery conviction. And some old theft from 06, theft by deception and theft by receiving conviction. That's it.
Okay. All right, state.
Yes,
Same
Your Honor.
facts.
Same facts, Your Honor. The defendant also has some theft convictions from the 90s as well. So his history of theft is quite lengthy. He currently has a $1,500 surety bond. We would also be asking for a stay away from the incident location and anti-theft course, given his open cases and his history that involve a lot of theft. No further contact with his co-defendant, Alexis Harlow. No drugs, weapons, or alcohol while out on bond.
All right, PD Cook.
Yes, Your Honor. My client is 47 years old. He's lived in the area his entire life. He's not employed. We would ask for a bond no larger than the one given to his co-defendant. We have no problem with a stay away or no further contact with Ms. Harlow or any of the other conditions. We would object to the anti-theft course.
All right, I'm going to order and leave it at the $1,500 surety bond. Stay away from the incident location. No further contact with the co-defendant, Alexis Harlow. No drugs, unprescribed medication, alcohol, weapons, or guns while on bond.
I didn't even know it was being stolen, man. People, they want from their brain.
Come on, Boozer. You gotta go. You gotta go. Go sit. Sit in the back room, man. Next, Your Honor, we're gonna go to position number 2. Ms. Clark. No, actually, my apologies. Position number 3, Ms. Clark.
Okay. This is 24 CR 006596Y. Rhonda Clark, charge of 1 count of theft by shoplifting, pretrial.
29, 2023 theft by taking trespass. That's open in state court. Got to open shoplifting battery in state court as well, and two bench warrants. I also went to felony earlier, not sure what the bond was.
She hasn't been seen in felony yet.
Oh, okay. Thank you.
Oh, but she has 2 open bench warrants.
Yes.
All right.
I'm not sure who the judges are. I usually write it down, but I didn't today.
Okay. All right, State.
Yes, Your Honor. Ms. Clark is a multi-state offender. She has 22 arrest cycles out of Maryland, 2 arrest cycles out of Pennsylvania, and then, of course, she has her 7 arrest cycles out of Georgia. She is accused of stealing bologna, ham, and body wash from the food depot located at 80 Northwest Broad Street in Fairborn. This incident occurred August 24th, 2024. She currently has a $600 surety bond. We would ask that that surety bond be kept in place at $600. Stay away from the incident location. No drugs, weapons, or alcohol while out on bond. This recommendation is based on her history and the amount of open cases and FTAs that she has on her record. She may also benefit from the social worker visit.
Excuse me, Judge, before you guys go into deep into the case, I just want to let you know, Mr. McLeod, this is your case. Apparently her bond forfeiture cases are assigned to you. They're from Judge Edie.
What is-
you know, yeah,
what is her name?
client, yeah, this client, she has 2 opening cases that you are assigned to.
Okay, what is her name? I did not hear her name. I'm sorry.
Oh, Rhonda Clark.
Okay, yes.
I can give you the case numbers. Yes, she's
Yes, Rhonda Clark is my client.
that's what I thought. This is a new charge.
Okay.
Gotcha. All right, Attorney McLeod.
Well, I did not know she was on the calendar today. I don't know anything about this.
Sorry to put you on the spot. You're up, but
I would certainly ask for signature bond for my client because I know she's not in a position to pay for bond. That much I do know.
Your Honor,
definitely.
I'm
Go
sorry,
ahead.
since I was not aware of the relationship either. If Ms. McLeod has no objection, I'll just fill in a few gaps if I could. Yeah, we don't know what's going on in felony court yet. We would ask, and I hope assume Ms. McLeod would join, or she's already stated her position. We're talking about bologna from a food depot. She's got a lot of fish to fry in felony court. We would ask, given her income level, again, we would join Ms. McLeod to ask for a signature bond. We would obviously have no objections to any stayaways or no further contact provision.
And the state would just object to a signature bond, given that she has bench warrants that are open. I think a social worker visit would greatly aid Ms. Clark. It does seem like she needs some help, but she can't just continue to steal.
Well, she definitely needs help. And it sounds to me like what she was stealing was sort of basic needs stuff, some food and some body wash.
I know, and I used to say that I get it and I understand on stealing necessities, but you just can't steal them. There's a lot of help out here and a lot of shelters and things of that nature that will give you the same thing for free without catching a case and stealing it. So I definitely want a social worker to visit her to provide some resources and assistance to her so that she doesn't have to attempt to or steal basic necessities. I will give her a a $60 surety bond, and I will lower it to $60. Stay away from the food depot in Fairburn, and no drugs, unprescribed medication, alcohol, weapons, or guns while on bond. That'll be the ruling of the court.
Your Honor, is it possible for someone in the public defender's office to initiate the social worker visit?
I can ask this, McLeod.
Okay.
I can drop a note to them. Thank you.
Thank you, Mr. Cook.
Sure.
Okay. All right. Next case.
Your Honor, next I'm gonna bring up the Next two conflict cases, position 5 and position 6, Mr. Josue Felipe Gutierrez and Mr. Oscar Felipe Gutierrez.
Okay,
Y'all gonna have to stand up. One on that side of the chair, the other one's on this side of the chair.
I'll start with position 5 on 24 CR 006598A, which is Mr. Felipe Gutierrez, charged with 1 count of battery family violence and a 2nd count of cruelty to children pretrial.
All right, so this is first arrest for him. And the other one, second arrest, 2019, driving without a valid license for number 6.
Okay.
That's all.
Are they brothers?
I'm not sure.
Yes, Your Honor, they are brothers.
They are brothers? Okay.
They are.
All right. And then on the second case, I'll just call it since I've got the pretrial, 26 CR 006599A, Oscar Felipe Gutierrez, same 2 charges, battery family violence, cruelty to children in the 3rd degree. And I'm assuming it's the same incident and facts.
Yes, sir.
Same. Okay. All right. Go ahead, state and give me the facts for both, or the facts for same.
Yes, Your Honor. This incident occurred September 15th, 2024, when officers were dispatched to 414 Dorsey Road in Hateville, Georgia, in regards to what was a domestic dispute. At least that's what they initially thought it was. Upon arrival, they observed a group of people in the front yard yelling. It appears that there were multiple fights going on at the residence. But for this particular case, defendant Oscar Gutierrez and Josue Gutierrez were arguing while Josue was holding a minor child in his arms. During the argument, Oscar pushed Josue. Josue then rushed at him and the two began to hit each other. At some point during the fight, the minor child, whose initials are JSF, was placed on the couch as the two brothers continued to fight until the fight was broken up by another family member. Oscar sustained bruising and lacerations to his face. Josue sustained bruising and swelling to his face. The state's recommendation is going to be a signature bond through pretrial services for both defendants. No further contact with each other at this time unless they are okay with having contact, then we would ask for no further violent contact, but of course we haven't spoken with either of them. I will defer to the court regarding a stay away. These are brothers. It seems like, you know, they just got into a fight, but I will defer to the court regarding if they need to stay away from the residence because they both live there. I think some anger awareness would be beneficial for the both of them. No drugs, weapons, or alcohol while out on bond.
Right. And who represents Josue?
I represent Jose, Your Honor.
Okay.
We are okay with the signature bond. I would, of course, prefer a signature bond to the jail. My client is actually gainfully employed, and what he tells me happened was that it was a disagreement, not between himself and his brother initially, but it was between his girlfriend and his brother's girlfriend. And he was just trying to separate the ladies. That is what happened initially. Mom was there, and mom took the baby outside. Mom, I was able to speak with mom through an interpreter. Mom's okay with both of her sons coming back home. And of course, they do want to have contact with each other because, as the state says, that they are brothers. But I just wanted to let the court understand that it wasn't just that these brothers started fighting. Apparently, both of their girlfriends got into an argument and were fighting. And ironically, of course, the girlfriends were not arrested, but they ended up being arrested.
And just to clarify, one of the girlfriends was arrested, Miss Michelle Castillo. She appeared on first appearance on September 17th. She was charged with battery, and her case number is 24 CR 006525J.
All right. Can't give them signature bind to the jail with the new bail restrictions. So it has to be through pretrial. I will give him a $3,000 signature bond through pretrial, 2,000 on the battery, 1,000 on the cruelty. I'm going to order him to have I don't know, can they go back home? I was gonna say no further
Yes.
violent contact.
Yes, Your Honor, I spoke with mom through an interpreter, and she definitely wants both her sons to come back home.
Well, that's if they know how to act when they go back home, I hope. So I'll give him a shot. No further violent contact with the co-defendant, with his brother, Oscar. And learn to talk it out. I'm gonna order a 2-day anger awareness course through pretrial. And no drugs, alcohol, weapons, or guns while on bond.
Thank you, Your Honor.
All right.
That concludes my business before the court today. May I be excused?
Yes, you may. Thank you. Have a
They
good
are, how old are they?
Excuse me, Judge?
My client is 20 years old, and I believe his
Okay.
brother is 23.
Okay.
Oh, okay. Thank you, Mr. McLeod.
Your Honor, that bond amount is for both,
I'm sorry.
is it for both defendants?
Well, let the state tell me what they recommend real quick, but it could be. Hold on one second.
Oh, I wrote it for both. My
You
bad.
wrote it for
I did
both,
too.
Oscar?
I
Yeah.
Wow. I can't believe you and pretrial think alike. Okay. Wow. That's good for a Friday. State, do you have anything to say, State, if I give them both the same bond and same conditions?
No, that's perfectly fine, Your Honor.
Okay, wow. Somebody owes someone lunch, but I won't say who. Anyway, I'll give them both the
Oh, I'll
same.
take it. I'll just take it.
Okay. All right.
What level was that, Your Honor?
I'm sorry.
What level was that?
Oh, level 1.
Thank you.
Next, Your Honor, we're gonna go to position number 4. Juan Croce, is it Croce? Croce.
Okay.
Croce.
Is that Croce?
Croce.
24. Oh, no, Croce. Okay. 24 CR 006597A, charge of 1 count of simple battery against a police officer, corrections officer. Not for sure which one. Pre-trial. On position 4.
Third arrest, 2024 trespass out of Vegas, 2024 criminal mischief disorderly conduct out of Pennsylvania.
Okay. Right.
Yes, Your Honor. Officers were dispatched to 2075 Piedmont Road in reference to a person injured call, as there was a male laying in the middle of the roadway. Officers did observe the defendant, who was very intoxicated and had visible bruises on various parts of his body. A Grady ambulance arrived to assess the defendant, and when the Grady employees were attempting to get him on the stretcher, he tried to run into the street. Officers were able to grab him, and while they were holding onto him, the defendant spit on Officer Bill Brooks's shoulder. He was taken to Grady to be evaluated. The state's recommendation is a $1,500 surety bond based on the fact that the defendant has arrests out of 2 different states in just this year alone, so he may be a flight risk. No further violent contact with Officer Bill Brooks. Anger awareness, no drugs, weapons, or alcohol while out on bond.
All right. PD Cook.
Yes, Your Honor, my client is 23 years old. He is not working presently, so he has no income. We would ask, we have no problem with any condition regarding stay away or no further contact. We would be seeking a signature bond at whatever level the court deems appropriate. And we would reject any kinds of anger management or any kind of course like that. Nothing further.
All right. I'm going to pre-trial. Would you take him or no?
It's his third arrest. He keep getting arrested. The jail was a recommendation.
And I don't want to do jail because I need to make sure he's coming back. I'll
Level
either,
to it then. If you give him a signature bond pretrial, level to it.
okay. All right, I will give him a $1,500 signature bond through pretrial. Level 2. And no drugs, alcohol, weapons, or guns while on bond. And that should be, oh, and stay away from the 75 Piedmont. Did the state ask for a stay away?
We didn't ask for a stay away as he was just in the middle of the road.
Well, okay, that's no actual location.
Yeah,
Okay.
but let me see if there's
I've said no alcohol while on bond, so hopefully he won't drink.
it looks
This-
like that incident location is a place called the Tattletale Lounge. So it makes sense if he was intoxicated and then left the lounge and was in the middle of
Fell
the
in
road.
the street. So I guess I'll order him to stay away from the lounge.
Hold on. Cook, does he live here?
Yeah.
Yeah, yes, he does live here.
Okay.
We've
Oh.
got an address and he's been here, yes.
Okay.
Okay. And we'll make him a level 2 to report him. All right, that's it.
Here we go. Thank you.
Okay.
Next, Your Honor, we're gonna go to position number 1, Mr. Quintavious Alexander.
'24 CR 006595A, Quintavious Alexander, 1 count of battery, pretrial.
Fourth arrest, 2023. Open case out of the cab, simple assault, family violence, criminal damage to property, 2nd degree. 2015 ag assault, felony obstruction, destroying or causing an injury to law enforcement animal. You got PTI for that. That's it.
State.
Yes, Your Honor. This incident occurred September 19th, 2024 at the Midtown MARTA station located at 41 10th Street Northeast in Atlanta. Upon arrival, officers met with the victim, Errol Jr., who is a MARTA employee. Mr. Jr. told officers that the defendant followed, threatened, and then struck him in the back of the head after he turned down the defendant's advances. Officers noticed a visible knot on the back of the victim's head. The defendant spontaneously admitted to officers that he did indeed hit the victim. The state's recommendation is for a $3,500 surety bond, no further contact with the victim, stay away from the Midtown MARTA station, anger awareness, and no drugs, weapons, or alcohol. I know this defendant only has 4 arrest cycles, but every single one of his arrests are for something violent. So that is why the recommendation is what it is. I would also ask that we sound for Mr. Errol Jr.
Say that name of the victim, Mr. Who Jr.?
Errol Jr. ERROL.
Oh, Mr. Errol. Okay. Errol Jr. Is he on here? Oh, all right. Go ahead, PD Cook. Or
Yes, it's my case, Your Honor. Your Honor, my client is 29 years old. He is essentially homeless at this point. He has a mother in the area. He's got a good address to receive mail. He's been staying at various shelters. He has no income. We would have no objection to the other conditions. It just is his income is an issue, and we would be asking for a signature bond, therefore.
all right. I'm going to order a $3,000 surety bond. And with that surety bond, I'm going to order him to stay away from the Midtown MARTA station. And I'm going to order no further contact with the victim, Errol Jr. No drugs, unprescribed medication, alcohol, weapons, and guns while on bond. That should be it. 3,000 surety. Next.
Next is going to be position number 2, Mr. Orlandis Clark.
24 CR 005720A, Orlandis Clark. Charged with 1 count of failure to use crosswalk, 2nd count possession of marijuana less than an ounce, and 3rd count possession of dangerous drugs. Pre-trial.
32. 2023, possession of a Schedule 3, 1, or 5 controlled substance with intent to sell of marijuana. Possession of cocaine with intent obstruction. That's open. 23 CP 221162. 2020 probation. 2009 reckless conduct conviction.
State.
Yes, I also saw that he had a 2020 arrest for robbery, purchase, possession, manufacture, sale, or distribution of marijuana, and then possession of a Schedule 1 controlled substance. This incident occurred September 19th, 2024. The incident location is 50 Upper Alabama Street, Atlanta. Officers were in the area already due to it being known for narcotic sales, loitering, theft, and violent crime. During their patrol, they observed the defendant being approached by a second individual named DeHaven Carter. The two had a hand-to-hand transaction of some sort, and then Mr. Carter is seen rolling up a cigarette or a blunt. The two men then walked to the underground and failed to use the available crosswalk. So officers then conducted an investigatory stop based on what they had just observed, and the defendant was found in possession of marijuana and multiple buspirone hydrochloride pills. The pills were in a cigarette box. When asked if he was selling the drugs, the defendant said no, and that he got the pills from some woman. The state's recommendation for the failure to use crosswalk is a $250 surety, for the possession of a $500 surety, for the possession of dangerous drugs, a $1,500 surety. Stay away from the incident location. No drugs, weapons, or alcohol while out on bond.
Okay.
This is my, Your Honor.
PD Cook.
Yes, Your Honor. Your Honor, my client is 43 years old. He's been an Atlanta resident his entire life. He's living now, in fact, in his grandmother's house. He works in construction. We would ask, given the nature of the charges, I think he uses we would ask, given the nature of the charges, for a signature bond at whatever level the court deems appropriate. Also, we would have no objection to any kind of stay away or restriction on contact. Nothing further.
Okay. I'm going to order a $2,500 surety bond. That'll be 1,000 on the marijuana, 1,000 on the possession of dangerous drugs, and 500 failure to use crosswalk. Total of 2,500. Stay away from 50 Upper Alabama Avenue. And was there no further contact or no?
No,
Just
there
to
wasn't,
stay
Your
away?
Honor.
Just to stay away. No drugs, unprescribed medication, alcohol, weapons, or guns while on bond. That should be it.
Your Honor, I apologize. What type of bond was this?
Surety.
Surety.
Thank you.
Mhm.
Next, Your Honor, we're going to go to position number 10, Mr. Anthony Jones.
Okay. This is 24 CR 006603J, Anthony Jones, charged with 1 count of battery family violence. Retrial.
I got first arrest.
Okay. State.
Yes, Your Honor. The victim in this case is Shantavius Carter, who was living with the defendant at the time of the incident. Ms. Carter reported that her and the defendant were arguing about calls and text messages that the defendant was receiving. And during the argument, the victim threw the defendant's phone, which upset the defendant. So in retaliation, he proceeded to punch her in the face and then drag her from the bed by her ankles. At the time of the assault, the victim was on the phone with her mother, who heard the commotion and called 911. When the defendant heard that the police had been called, he took his things and left the location. Ms. Carter did sustain a scratch to her face, a bruise to her chest, and a bleeding cut on her ankle. Our office has spoken with Ms. Carter, who states that her and the defendant are no longer in a relationship. They don't live together and they don't have any children. She confirmed the events in the warrant and stated the incident location was her residence, but she no longer lives there. She states this is the first time the defendant had been violent towards her, and she has not seen or spoken to him since the incident, but she wants no contact with the defendant. The state's recommendation, given the fact that this is the defendant's first arrest, is a signature bond through pretrial services, no further contact with the victim, anger awareness, no drugs, weapons, or alcohol while out on bond. I would ask the court to sound for Ms. Shantavius Carter.
All right, Shantavius Carter. All right. Go ahead, PD McLean.
Yeah, Your Honor. We have some questions here. Apparently, we may have an alibi situation here that wrong person. Is the boyfriend of Shantavius Carter from this date in October of last year? Is that person 6'5" or 6'6" and weighs 240 or 50 pounds?
What are you asking?
My defendant on October the
But hold
whatever the
on,
date
this is
was in his
something that
warrant.
I cannot sort out here, sounds like. You have to talk to the state about that. I'm just trying
Understood.
to-
I don't know if this is the right
think we've
venue
got-
for the
It's
conversation.
not, it's not. I'm not going to do anything about that because I don't know enough about it. So I'm not going to rule that this is the wrong person. You know, we had one the other day that defendant that said he was incarcerated at the time the crime was committed, and we had that technically and kind of looked it up at the moment, but I still did not dismiss the case. So I'm not going to do that. I might give him a signature bond based on something, but I'm not going to lead into that for the next 30 minutes either, because I'm just trying to determine bond.
His fiance is on the Zoom, Your Honor. Signature bond be appropriate if it needs further investigation. We ask for a simple signature bond through the jail with no conditions.
I think this is a bail restricted offense.
It is the battery family violence. It has to be a surety.
Well,
Or I'm sorry, SOB pretrial.
okay. That works, level 1, if we can do that. But I
And you
believe
based on mistaken identity?
mistaken identity is not, it's just not to him. He didn't do it. He was in North Carolina. He lives in Charlotte.
Well, it's his first arrest, so I will give him a signature bond through pretrial. I don't like the fact that no pretrials and getting, he's not a Georgia resident.
This address, let's see, this address
Can't hear
is
you.
on
You
Parkway. I
got
don't know if
terrible
that's
connection today.
Yeah.
Cannot understand you. Let's try it
Right.
again.
Shannon Park.
Mr. McLean, you're totally out. Lips are moving, no words coming out. Sound like you're in a hole somewhere. Your connection is terrible today.
Maybe the weather. I'm not sure up here. It's a little overcast. A signature bond through pretrial. We'll get it straightened out and marshal our facts and witnesses.
All right, I will give him an SOB $3,000 SOB pretrial level 1. No drugs, alcohol, weapons, or guns while on bond. And is there no further contact
Yes, Your Honor.
with the victim? No further contact. Tell me the victim's name again.
Shantavius Carter.
Okay, if he doesn't know him, then he shouldn't have a problem staying away from him.
Wouldn't know how to run if he ran into him on the street, but that's okay.
All right, signature bond, 3,000 SOB pretrial, level 1. All right. Thank you.
Thank you.
Next, Your Honor, this is gonna be position number 15, Mr. Ronald Roberson.
24 CR 006591C, Ronald Roberson. 1 count of fair evasion, 2nd count of criminal trespass. Pretrial.
39/2024. What is this? Battery? Wait, sexual battery. 2018 probation, 2016 probation, 2014 probation, 2014 battery DV, 2013 probation, 2012 FTA, 2012 entering auto conviction, and the 2011 peeping conviction. That's it.
All right.
Judge, it's my understanding that he currently has a $1,600 good bond. We're willing to reduce to a $1,000 surety. That's $500 on each count, as well as to stay away from all MARTA stations. This is based on both his history, his extensive history, as well as, you know, he entered through the emergency exit at the MARTA station without paying the fare. When the officers ran him, it showed he has a permanent ban from MARTA effective in May of this year. So he knew he wasn't supposed to be there. So for those reasons, we're asking for that total $1,000 surety bond. Stay away from all MARTAs.
Let me double check here. Based on my discussion with Mr. Roberson, I believe that's okay with Mr. Roberson to have a $1,000 surety bond. Is that correct, Mr. Roberson?
Yes.
Okay. We agree, Your Honor.
All right. $1,000 surety bond, 500 on each. Stay away. You're already banned from MARTA. Cannot go there. No drugs, alcohol, weapons, or guns while on bond.
Next, Your Honor, we're gonna go to position number 16, Eric Smith.
24 CR 006592F, Eric Smith. 1 count of battery family violence. 2nd count of simple battery family violence. Date? I'm sorry, pretrial.
Smith, second arrest, 2024 FTA. That's it.
State.
The state is requesting a $3,000 signature bond through pretrial at level 2, as long as no further violent contact with Christina Roberts, and to complete an FVIP program while out on bond. These facts allege that this defendant grabbed the victim, who he's lived with for 2 years, then pinned her to the wall. She did have visible marks that were observed on her arm, which were consistent with being grabbed. We have had contact with this victim, and it's my understanding that she's on the Zoom now. Confirmed they are in a relationship. They live at the incident location together. She told us she was not in fear of the defendant and wants to continue contact. But based on the his FTAs, as well as the violence alleged, we'd be asking for that $3,000 signature bond through level 2 of pretrial and no further violent contact. Miss Christina Roberts.
Hello.
Hi, do you wish to address the court today? Yes or no?
Yes, I can.
All right, raise your right hand for me. Confirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury.
Yes, I do.
All right, good. Are you in fear of Mr. Eric Smith?
I am not.
Do you want to have any further contact with him?
Yes, I do.
Okay. All right. And it says you do or don't have children together?
Do not.
Okay. All right. Anything in cross-examination from counsel?
No, thank you, Your Honor.
All right. All right, you can mute yourself. Thank you for your time. Go ahead, PD McLean.
Your Honor, he would like to accept the idea of the signature bond. And I don't know that a FVIP, the 24-week class would be necessary right now. Maybe an anger awareness or something would be more suitable at the bond level. But he does own business, and it'd just be a matter of affording it, which he can do. But it might be more appropriate in terms of the stage of litigation for it to be anger awareness at this point. I don't doubt that maybe in the long run they'll work on a DVIP. Gosh, she could do that voluntarily.
Your Honor, may I speak again? I'm sorry.
You have to turn on your camera.
Yes, ma'am. Okay, I'm here. I just want to, can you hear me, Your Honor?
Yes, but I'm not going to debate the facts or argue the facts with you.
Oh, I'm not. I was
Okay.
context. I just wanted to share that we both attended couples therapy in 2023 and individual therapy, and still both attend individual therapy. So just wanted to add that note.
Okay, thank you. All right.
That's all I have. Nothing further.
I will order that $3,000 signature bond through pretrial. Level 2, $1,500 on each case. No drugs, alcohol, weapons, or guns while on bond. And no further violent contact with Ms. Roberts. And I guess that's it.
Yeah. Next, Your Honor, we're going to go to position number 13. Mr. Nicholas Pittman.
24 CR 006589G. Pittman Nicholas, 1 count of simple battery, 2nd count of criminal trespass, pretrial.
7, 2023 trespass, obstruction, possession of marijuana. That's 23 CR 0054128. Let's see. He's out on pretrial for that. Got an open shoplifting, terrorist threats, obstruction, 24 SC 003488. Open case out of the cab, theft by shoplifting.
All right, state.
It's my understanding that his bond is currently set at 2,500. We would ask that it remains as set. That's 1,500 on the simple battery and 1,000 on the criminal trespass, as well as to have no further contact with Raul Sanchez and to stay away from all MARTA properties. I do not believe this is a good candidate for a signature bond. He was just ordered by Judge Lal on in September of last year to stay away from MARTA and he went back to MARTA. This incident occurred at the North Avenue MARTA. He was on the platform with this victim, a person he does not know, and he just randomly slapped the victim in the face with an open hand without any provocation. The defendant had an active suspension from MARTA that was issued on July 15th, 2024, and it does not expire until October 13th. We did have contact with the victim. He is on the Zoom right now. He did confirm the events in the warrant, stated he does not know this defendant, and he has to go to this MARTA station every day for work, and he's afraid of this defendant. I mean, he was attacked for no reason. Mr. Sanchez.
Sanchez? Sanchez?
Yes, I'm here.
You have to turn on your camera.
Sorry. Hello.
Hello, do you wish to address the court today, yes or no?
Yes.
Raise your right hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. Are you in fear of Mr. Nicholas?
Yes.
And do you want to have any further contact with him?
No, please. I don't know him. I never met him before. I don't know the reason why he attacked me. And yes, that's it.
Okay. All right. Anything else? Any cross-examination?
None.
Okay. All right. Thank you for being here. You can mute yourself. Go ahead,
And
Mr.
Judge,
McClellan.
I'm sorry, I meant to say earlier, we would be requesting a social worker visit as well.
Oh, social worker. Okay. All right. Go ahead, PD McLean.
Your Honor, a social worker visit is appropriate. He just got a job as a dishwasher, a full-time job, 40 hours a week. Great job. He's been having some residential problems in the last several years. He has grown up in an Atlanta suburb, and he's been struggling financially and trying to get his act together. But this job looks like it's down the tubes unless there's some way that his parents might make a bond. But so we would ask the court to consider a signature bond. If the court can't lean towards a signature bond, we'd ask for 1,000 surety. That would be something the parents would come through. He doesn't have funds because he hasn't even gotten his first paycheck. And we don't have much to say about the facts. I mean, what can you say there?
Yeah, just the facts are not great. To just randomly, do that makes you wonder. So I will order a $2,000 surety bond, 1,000 on each. Stay away from Marta, correct?
Yes.
No further contact with Raul Sanchez. Social worker visit. See if we can help with some other concerns that we have. No drugs, unprescribed medication, alcohol, weapons, or guns while on bond. All right.
Very good.
Hey, what happened to Franklin?
You want to wait till the end of the calendar, Mr. Howard?
No, because he out on pretrial. So if they NOD, I'm about to do this bond surrender before you walk out the door.
We did NOD it.
All right, thank you.
Hey, go sit down. I'll answer your question later. Next, we're going to go to position number 7, Mr. Lawrence Fuller. Good afternoon, y'all.
'24 CR 006600G, Lawrence Fuller. Excuse me, 2 counts of battery, 1 count of disorderly conduct. Pretrial.
He got 12 total 2024 ag assault, terrorist threat, stuff by taking out of Smyrna. That's open out of Cobb, 2019 battery conviction, 2017 threatening a public official conviction, 2014 resisting peace officer conviction. That's it.
Yeah. Okay.
Yes, Your Honor. And I believe those convictions are out of Illinois. So this defendant is a multi-state offender. He has 4 arrest cycles in Georgia and 8 arrest cycles out of the state of Illinois. This incident occurred at the Fin and Feathers Lounge located at 1136 Crescent Avenue, Northeast Atlanta. Officers were flagged down in front of the location in regards to people arguing and getting physical at the location. Officers observed a verbal dispute between the defendant and one of the victims, Brennan Harper. Officers were about to attempt to de-escalate the dispute when the defendant followed Mr. Harper into the street and then punched him twice in the face, causing a bruise to Mr. Harper's face. Officers detained the defendant and then spoke with Mr. Harper, who stated that the defendant had been kicked out of the lounge for being disorderly and then came outside and started randomly attacking people. Officers were then approached by a Mr. Corey Heron, who had blood on his face and a visible laceration to his lip. Mr. Heron told officers that he had been attacked for no reason by the defendant while he was standing outside the lounge talking to friends. The defendant told officers that the two victims had disrespected him and so he had attacked them because he was standing up for himself. The defendant had no visible injuries on his person. The state's recommendation is going to be based on the fact that the defendant has numerous convictions for violence, numerous arrests for violence, and an open aggravated assault out of Cobb County. We are recommending a $2,500 surety bond for each count of battery and a $1,000 surety bond for the disorderly conduct. Stay away from the incident location, no further contact with the victim. Anger awareness would be beneficial for this defendant so he can learn how to control his emotions. No drugs, weapons, or alcohol while out on bond. I would ask the court to sound for Brennan Harper and Corey Heron.
All right. Brandon Harper, Corey Heron. All right, this case, PD Cook.
Yes, Your Honor. Your Honor, my client is 32 years old. He's living in Winder with his sister and intends to stay in the Atlanta area. He's a high school graduate. He's now enrolled in some IT classes. He'll begin in a few days. He also has a job he'll begin in a few days. He denies the allegations that stated in the warrant. His position is that he was outside the club, that he was threatened by the alleged victim, and that his actions were in self-defense. He did not know the alleged victims, and that he was acting in self-defense. He has not started work yet, and so we would, so his income at this moment is actually zero. We have no objection to any stay away or any restriction on contact of any kind. They don't really know each other. It's not likely they would see each other again. But given his limited income, zero, we would be seeking I didn't catch all the background, so I'm not sure if it would be bail restricted. If not, we would be seeking a signature bond. If so, we would be seeking a surety bond at the lowest amount possible. Thank you.
I'm going to order a $5,000 surety bond, $2,000 on each of the batteries, $1,000 on the disorderly. No further contact with the victims. Looks like Brendan Harper and Corey Henry. Stay away from the incident location. No drugs, alcohol, weapons, or guns while on bond. That's it.
Thank you, Your Honor.
So we'll have to dig it out. Next, Your Honor, we're going to go to position number 14, Mr. Price.
Aye.
Good afternoon, Your Honor.
This is 24 CR 0065990G. Mr. Price is charged with 1 count of theft by shoplifting. Pretrial.
2022 suspended license. 2018 simple battery against law enforcement battery DV conviction. 2018 and 2017 probations. 2016 probation. 2015 shoplifting conviction. 2015 entering auto theft by taking financial transaction card theft conviction. 2014 theft by receiving, possession of a firearm by convicted felon conviction. 2014 obstruction conviction. That's it.
Okay.
Yes, Judge, we would be asking for $1,000 surety bond as well as to stay away from all Target stores. You did hear the history. He has a history of theft, so we believe there's a high risk of reoffense, as well as these facts allege that this defendant, along with his mother and co-defendant, entered Target and rang up a number of household goods by replacing the barcode with a cheaper priced item to pay significantly less than the total. They passed all points of sale, and he was identified by his card and he was identified in video. So based on the facts, and mostly the history, we believe that risk of reoffense is very high. We'd be asking for that $1,000 surety bond as well as to stay away from Target.
Mr. McLean?
Your Honor, my client had some problems in the past that involve drug usage, and it accounts for a good bit of his criminal history. He got rehab. He was a graduate of a different county's 18-month program drug court in 2019. Recently, he has completed a course in audio skills, technical audio skills, at the Conservatory of Audio, I believe it's Arts and Sciences, I think is the name of it, independent educational institution. He works at Atlanta Cold Storage in Forest Park. The co-defendant nature of this case and what part he walked in on in the facts, this is not the trial, so I won't even go there. The state's recommendation is actually workable for him. Having said that, we would ask the court that given that there is an explanation for why there's a history like he has, that perhaps a censure bond would also be reasonable.
No, not gonna do a signature bond with 21 cycles. So certainly not that, but I don't know, 1,000 surety. I don't know how much was the stuff they stole in Target.
It would cost him the 10 to 12% plus some fees that they charge. So it'd be a couple $100, $150, $180 to get out.
I don't know about him getting out with 21 cycles and his history. And even though there may be a reason or excuse, his history is terrible. I'll go ahead and reluctantly order that 1,000 surety bond, but I hope he's done with that life and doing such things. It needs to be higher. Almost
Yes, sure.
give him a cash bond and stay in longer. But think about what he's doing. Sounds kind of weird. He did it with his mom, so I don't know. Maybe she's teaching him that, but all right, $1,000 surety reluctantly. It's better stay away from Target. He's really trying to change his life. Do it. No drugs, alcohol, weapons, or guns while I'm bond.
Very good.
Come on now. Can I say something to the judge, please? She's not gonna let you no more.
I just lost my father and I don't have any money. I was just defending myself. I didn't just randomly assault anybody. I was just defending myself. I was with my girlfriend. I swear to God, I did not randomly assault anybody. This might not change anything. I don't have any money. I can't get out of jail. My father just died. I'm supposed to be driving down to Chicago right now with my family for his memorial. I did not just randomly assault anybody. I was just defending myself. And I appreciate you giving me a $700 bond, but I don't have any money. I don't have anything.
Your family can't come up with bond.
No, ma'am, we all struggling. We just had to scrape up some cash to get my father cremated. I don't have any money. I don't have anything. I'm broke.
I don't even remember which case is this.
This Lawrence Fuller. I'm Lawrence Fuller. I'm sorry, ma'am. I know this is not.
This is Lawrence Fuller. He had 2 counts of battery and 1 count of disorderly conduct. You gave him a $5,000 surety bond, stay away, and no further contact.
Please, ma'am. I don't have.
Oh,
any
that
money.
was the one, it was 2 victims
Yes, it was 2 victims.
that he slapped on Marta.
No, this was at
Oh.
a lounge called Fin and Feathers.
Oh, that's
He
right.
punched them both in the face, basically.
At the lounge, yeah.
Yes.
And he's 32, had 12 cycles, 24 aggravated assault in the open case in Cobb.
That is correct.
And that was this year.
Aggravated assault was by my ex-girlfriend. It was an allegation. She signed affidavit because she made a false report. I'm sorry. It's actually, I go to court for that on the 10th. I did not assault her or steal her firearm or threaten to shoot her.
Well, you've had 12 encounters with the police, though.
I have, ma'am, and I'm sorry. And I changed my life. I'm changing my life. I start ITT Technical Institute next week, and I start my new job on Tuesday. Please, Your Honor, I just want to go home. Please.
I bet everybody there wants to go home, because you got to make better decisions. You know, if I would have put you on a pretrial, I would have had you taking some anger management. You got to get a hold of your life. But you're 32 years old.
I just started a business, man.
Old enough to know better.
I just started a business. I am doing positive things in my life again. I was just protecting myself. I was defending myself. They came up to me. I
know. I don't want to hear too much more of the facts, because everybody always says, I was defending myself, but maybe the officers didn't try to sort it out. But your history is not good, and you've got a recent open case, so I'm gonna leave it at the 5. It's not a lot. Maybe your family can try to come up with it, but if you're gonna turn your life around, do that. Then guess what? Then I won't see you in here again. Okay? So you gotta make better choices. So you'll come up in a couple of weeks if you don't make bond before then.
You bring them back here again, officer. Open the door. Open the door. What are you on? Who's up? Come on. How much longer? You get up? About 7. Okay. And next, y'all, this is going to be position number 8, Mr. Jabru, Johannes Jabru.
Oh, this is the last one?
Yeah, courtroom is clear.
Okay. Can we stop?
Stop the feed as well.
Right. Can we stop streaming?